I'm interested in exploring issues around the current law. And in the policy memorandum, it talks about how the member in charge believes that the current legal position is unacceptably unclear, and there is currently no specific legislation in Scotland which makes assisted dying a criminal offence, yet it's also possible to be prosecuted for offences such as murder or culpable homicide for assisting the death of another. So I'd be interested in what you think, what your assessment is of the extent to which the current criminal law is clear or not, and to what extent there's a 2016 case of Ross versus the Lord Advocate which made the position clearer. So I'd be interested in just exploring issues around the current law.
Thank you. Good morning. It is recognised that this is a particularly difficult and emotive area of the law that raises important issues, and therefore it is quite proper that any proposed change to the law should be a matter for Scottish Parliament. It's the job of prosecutors in Scotland to apply the laws that are there. But if it assists, I can talk through the current process in relation to assisted dying in Scotland. As the committee will be aware, in the documentation that I know the committee have before them, there are historical differences in the way that the law has developed, and in fact the criminal justice systems have developed between England and Wales, which makes our systems quite distinct. Suicide is not a crime known to Scotland, and there is not a distinct crime in Scotland of assisted suicide. In contrast, there is a statutory offence in England and Wales of assisted suicide, but the Suicide Act does not apply in Scotland. In Scotland, if someone does assist another to take their own life, such cases would be reported to the Procurator Fiscal as a deliberate killing of another and would be dealt with in the law relating to homicide. Under the law of homicide, we would have to consider whether there was sufficient evidence to determine an offence had been committed, that the individual was the perpetrator of that offence, and that the individual had the requisite intention to commit the offence. We would also, and I think in terms of the case that you referenced, Ms Harper, we would have to show that there was a direct causal link between the actings of the perpetrator and the deceased's death. So it would have to be a significant contributory factor to the death. So there is a considerable amount of case law around causation and contributing factors, which would require to be really carefully considered in the circumstances. And we do say that in every case, we have to consider all the facts and circumstances that are before us and the evidence with the cases that are reported to us. Once we've reached that stage in the process, we would have to consider whether any prosecution would be in the public interest. And the criteria for deciding whether a case should be prosecuted is set out in the Prosecution Code, and the Prosecution Code is an available document on our website. There is, the taking of another life is one of the most serious offences in Scotland. So there is a high public interest in prosecuting aspects of homicide where there's sufficient available evidence. Ultimately, if we decided to prosecute it, it would be a matter for the jury to decide whether the standard of proof had been reached and to determine whether somebody was guilty of culpable homicide. And it would be for the court to ultimately determine the appropriate sentence, taking into account any mitigatory factors that exist. So that's the current law in Scotland in how we would consider cases that were reported to us in assisting in suicide.
Okay. I'm just also, and anybody else can come in if you choose as well, does the bill as it's laid out right now propose there would be a pathway for somebody to end their life without others then being prosecuted? And does the bill interact with the current law in a way which will facilitate prosecuting offences around suicide and assisted dying, which is not covered by the requirements of the bill? Because this bill is about somebody choosing to to be assisted to end their life if they are terminally ill.
Good morning. I'm happy to answer that. There is a provision in the bill, obviously, that sets out there would be no criminal liability where someone has lawfully provided assistance to someone else to end their life. So that provision, the protection provided by that provision, would only therefore apply if that assistance was lawful. So I think the first thing that we would consider would be whether or not the process had been lawfully adhered to. And if the assessment was that it hadn't been lawfully adhered to, then the existing criminal law would apply to anyone involved in any potential offence or offences relating to that.
Okay, because I'm thinking about healthcare practitioners. I'm a registered nurse myself. I probably need to remember and say that. But yes, so it's for healthcare practitioners who are participating in the process of helping somebody in their life.
Yes, I mean, I think that's why it's important that the provisions are as clear as possible, not only for the benefit of those investigating any death, but obviously for the benefit of those who are seeking to follow the procedures in place. I think the greatest degree of clarity and certainty possible would certainly be welcomed by us.
Okay, thanks.
Brian Bettle.
Right, thank you, Convener. Good morning to the panel. Coercion is one of the main issues that has been raised almost in every single panel that we've spoken to. But so I wonder what your considerations are around whether the bill as it's written is sufficiently clear to enable prosecution, and potentially could you maybe give us an idea of what kind of evidence you'd be looking for to be considered in this context? I suppose, given Mr. Shanks, probably a good place to start with that. Can I ask you? Or Miss Buchan?
Probably one from Miss Buchan in the first instance.
Thanks. Yeah, I mean, I think one of our observations in relation to the bill is particularly around provision 61C. It talks about medical practitioners making an assessment about whether the person has been coerced or pressured. I think, as my colleague Andy said, clarity around what that would mean in terms of the process. What would a medical practitioner require to take into account to determine whether somebody has been coerced or pressured? I think that would be helpful in terms of the medical practitioner having understanding of what process they would require to carry out to satisfy themselves to that. And it is not clear from the bill how, if the medical practitioner has any concerns around coercion, how those concerns might be raised with the relevant authorities. There might be scope for disagreement amongst practitioners in respect of whether there is coercion or not. So it's something, again, I suppose one of the observations around clarity in terms of what do we mean by coercion and pressure? How would a medical practitioner determine whether there's coercion or pressure there? How would they intimate whether there had been coercion or pressure in the process for that to be considered? There is no offence of coercion in Scots law currently. It's more ordinarily discussed in the context of defences, and I suppose in terms of our own consideration, much would depend upon whether the coercion came to light during the process or if the coercion was raised by potentially another after the process had completed, and that would determine for the police and for the Crown how they would require to consider that in terms of the offences.
I suppose a supplementary to that would be if coercion is not currently an offence, presumably within the context of this bill, coercion would become an offence. And I think one of the questions I would ask is that we're asking the medical profession, who are not the legal profession, to make a judgment on something that is potentially breaking the law. Is that fair, Mr. Johnson?
Yeah, from my perspective, we raised exactly the same issues, that this aspect of coercion or pressure during the process, we would say exactly the same thing. If that gets referred to the police for an investigation, what's the scope and scale of our investigation, and how would we report that to the Crown? The bill creates an offence at those stages. It doesn't seem to create the offence after the event, and that would be our primary concern, that after the event a distant relative or somebody else, a third party, comes in and says, we believe there was coercion that has led to, where do we sit then? So we would say there would need to be clear guidelines for those medical practitioners that are making those statements, because in their statements, both the coordinating and the independent are both asked to declare at point 2 that they are not knowingly. So how do they know that? What's the nature of the questions? What's the nature of their inquiries with the individual that's in front of them around whether there's been a broad conversation between interested parties in their family, for example? So we'd be really keen that there is clear guidelines for those medical practitioners as to how they would come to that conclusion that there hasn't been any or knowingly no coercion or pressure.